Janae here, and today we are discussing current events that pertain to the music and entertainment industry with none other than music and entertainment attorney Cassandra Spangler. The information provided in this video is for informational purposes only and not for the purpose of providing legal advice. You should contact an attorney to obtain advice with respect to any particular issue or problem. So I am welcoming once again Miss Cassandra Spangler. She is a music attorney, and she is going to be talking with us today about a few current events that came up over the last several weeks. A lot of them have to do specifically with copyright, which we have covered pretty extensively. We had specific conversations that we have out there about copyright. We also have touched on copyright within our other discussions because copyright is kind of central in the music industry. Would you agree with that, Cassandra?
Definitely. Yeah, I think it all comes down to your intellectual property is really your product. And so that, copyright is one of the primary ways of protecting that.
And, I just kind of jumped right in there because we've had so many talks that by now everybody's got to know who you are and your voice. If you want to say something about who you are and what you do, there's no reason that we can't start there.
Sure. Yes. Thanks as always for having me, Janae. It's always great to speak with you. My name is Cassandra Spangler. I am an entertainment attorney, work primarily in music, and I'm based in New York City. And I handle, contracts, copyrights, trademarks, all of that stuff. And if anyone is looking for a good background on those topics, they can check back through Janae and my prior talks because we, as Janae mentioned, kind of go over everything really in detail and give you a good overview of these different concepts.
So, we will get started then and just jump into some of these different current events that we gathered over the last few weeks. And one of the ones that I would like to start with has to do with sort of the marriage of copyright and trademarks, which we've also covered very extensively. And we know what we're talking about in terms of which articles, but we're going to talk in generalities because it does affect different people pretty much the same way. So, copyrights and trademarks. It sounds like from this article that one can help you with the other and vice versa.
Yeah, I think that, they're both different forms of intellectual property. So again, as an artist, essentially your product that you're selling is your intellectual property, and copyrights can protect certain types of that intellectual property, your recordings, your musical compositions, your lyrics. If you're a visual artist, your photographs, your paintings, and trademarks can protect a different piece of your intellectual property, which is your brand, your name, and your logo. There was an artist in this article who was discussing the value of both because they both have value and they are related in the sense that if you're an artist, then your brand is your music, and the name that you are selling that music under would be protected by your trademark. So they both can be very valuable, especially the more known the artist becomes, the more value that brand name has, as well as the more value the copyrights to their music will have. And so it's important to make sure that you've registered both of those, your copyrights and your trademarks, from the beginning. So this way, once they increase in value, you're already protected.
Okay. And so we are actually going through this right now, you and I, because you're going to be doing some trademarking for me. And what I've been learning from you is that you have to, first of all, show that you already use these things. So you can't just pick something that you know is really popular and look it up, see it's not trademarked, and then go, oh, I think I'll trademark that if you're not actually using it. Is that correct?
Right. Yes. You have to show that you're actually using it or that you have what they call a bona fide intent to use it to sell those products. So you can't just, see that somebody has failed to register their trademark and then rush out to register it and try to sell it back to them or something like that, which people have tried same thing that people try to do with domain names, and that's actually illegal. So you have to really show that you're either using that as a brand name or that you have a good faith intention to begin doing that in the near future.
Okay. So people can kind of rest easy there and say, "Oh my god, I have so many things I have to trademark. I got to get it all done right this very second." It may not be that you have to get it done this very second. The sooner the better, but hold on, right?
Yes, the sooner the better because you still do run the risk of someone else. So someone else cannot in bad faith, rush out and register the trademark in someone else's name in order to try to make money off of it. However, you do run the risk that someone else innocently starts a business under the same brand name selling similar products and then registers the trademark before you and can potentially block you from doing it. So the sooner the better, yes, but I know people work with limited resources and it can be overwhelming as an independent artist, a small business. So, you can prioritize what you're really planning to use as your primary brand and start with that and then branch out from there.
Copywriting, that's one way to protect yourself. Trademarks, that's another way to protect yourself. When you are trademarking, you can do your name. You can also trademark phrases.
You can, yeah. So if you're using a phrase as sort of a slogan for your products, for example, Nike, just do it. Now, I don't know whether or not Nike has trademarked just do it, but that would be an example of a type of a slogan or a phrase that you could potentially trademark.
So if one of my songs, if the title is not been trademarked by anybody else because they're not using it, I could actually trademark the title of one of my songs.
Unfortunately, no. So titles of books and titles of songs and movies cannot be trademarked unless it becomes a brand. So if you have, the name of a song that you then develop into a line of products based upon that song using the same name, then you could potentially do it. But just the song name alone or the title of a book or a movie cannot be trademarked by itself. The way that trademarks work, they're based upon various different categories of products and services. So you have to show that you're using the trademark, the proposed trademark, to sell those specific type of products that you list. So if you then develop a line of merchandise, clothing based upon the song, which a lot of artists do, you could then trademark the name in connection with clothing.
So that's again ways that artists can protect themselves and protect their line, if you will, of products. Anything else on that particular article?
The only other thing I would mention that this article that Janae is referencing, there's also some talk in there about artists owning their masters, which is kind of a hot topic nowadays. You hear a lot of artists in the media discussing this issue. I think Janae and I have covered it more in detail in a prior talk as well. But I just want to make sure that people understand when you're signing with a record label, part of the deal typically is the label is going to pay for all the recording costs for your album. And those can be very extensive, hundreds of thousands of dollars, maybe $1 million in some situations. So the bargain is they're paying for those costs, and in exchange, they're going to own those recordings because they paid for them. So I think artists need to understand that because a lot of artists are coming and saying, well, I want to own my masters. I'm not signing anything unless I own my masters. And I think they need to understand what comes along with that means you have to pay for those costs on your own. So if you're able to do that, great. That puts you in, a much better position in the long term. But most artists, especially just starting, are not able to do that. And so they have to kind of understand that it's not automatically a bad thing that the label owns the masters because it means they're paying those recording costs for you. So, a lot of artists, especially later in their career, when they're more developed and they have more resources, can then try to go back and purchase their masters back basically for large sums of money, usually. But I think that artists who are just starting out, who don't want to be independent and want to go the label route, have to understand that that's not, in most cases, something that you can ask for at the beginning.
Very good point. Anything else on that topic?
No, I think that's it for that one.
So then we also had actually a few on the topic of incidents happening at concerts where people have been hurt or killed. We talked about some of the expenses that people don't really think about and why it's important to set up your business in a way that your personal property is protected in case something like these tragedies happen while you're on stage or whatever. So, do you want to talk about that in relation to these articles that we came up with?
Yes. Yeah, it's been obviously in the news a lot recently because of the horrible tragedy in Houston. But, it's not the first time, unfortunately, that things like this have happened. And there can be a huge amount of liability that artists take on from live shows because there can be a lot of safety issues. I mean, I remember also years ago, and again, more recently, issues with fire. I mean, there have been concerts where fires have started and people have died. So, there can be a lot of different liability issues that come up with live shows, especially larger shows, festivals. And so it's important for artists to, as Janae mentioned, structure the business in a way. This is why a lot of artists will use a separate LLC or a separate corporation for their live shows to try to segregate out any liability that they may incur from, their music income or their merchandise income or their publishing income. Because if you are doing it all under one entity, then if someone gets hurt at your show and you get sued for $1 million, all of your income from all those sources can be at risk. So it's important to make sure that the business structure is set up in the correct way, to make sure that you have the correct insurance for these shows in case any liability should happen. And then, of course, to make sure that the show is as safe as it can be and that things are not falling through the cracks, that security is in place, that there are plans in place for when these things happen, because they do happen. And, it's tragic and horrible. And so, to the extent that it can be prevented, of course, that's the best way to go.
Right. And today, well, over the last several years, shows have gotten bigger and bigger, and the use of pyrotechnics is just running rampant. But it's not even just that. You could have some sort of staging fall. You could have scaffolding fall down from, flying over the crowd. All kinds of things can happen. I would assume, too, people are drinking. Some people are doing drugs
Yep.
at these concerts. I don't know the liability for what an individual does and ends up dying or getting very sick, but I would assume that is a possible lawsuit as well.
Yes. Yeah. And I mean, I think that the recent situation exposed a lot of holes in general that happen at a lot of these, especially large festivals, which, as Janae mentioned, have become more and more popular in recent years. And I think, there were a lot of issues. I think we'll have to wait and see what the final report is. They're still investigating. But for instance, I read that there were 5,000 people that snuck into the show at the beginning, who, it already was 50,000 ticketed fans, and then an additional 5,000 got in without tickets. And so all of these things that come up that maybe have been a problem at other shows and just, no one got hurt over it. I think all these things will have to be addressed for these large shows moving forward. I think we're going to start to see a lot stricter safety protocols and a lot more security and things like that. And, I think that it wasn't just this particular festival. I think it's just so happened to be this one where, unfortunately, it was a lot of different factors played in, and a lot of people died. But I think it could have happened at other shows previously. I think back also to when they did the Woodstock anniversary. I forget exactly what year. I think it was the late 90s. They did like a 30-year anniversary or something of Woodstock. And that just turned into a horrible, horrible situation for many reasons. I think one of which, they were not providing people water. They were charging ridiculous amount for bottled water, no free water. It was in the middle of the summer. And so you have all these different things that need to be factored in. You need to make sure that people have water and restroom facilities and all these things, and things can start to pile up, and then bad situations can happen when all these details are not taken care of.
Right, right. So we have that, and I know we talked about that type of stuff in previous recordings that we've done, so people can go back and take a listen to some of that, and so that you have some ideas on how to protect yourself if you're going to be doing live shows or selling merchandise, even. So then we also had a situation come up recently that involves copyright infringement when it comes to photographs. And we had a very specific conversation, you and I, about that as well, actually, recently. So this is yet another example of not assuming you own something because it's your likeness. And in this situation, paparazzi took pictures of a person, and that person then posted the pictures on their social media account. And then the photographer sued that person, even though it was pictures of the person who posted it, which it just baffles me. But again, if you look at copyright law like we have, it makes sense.
Yes. Yeah. I think it's important for people to keep in mind, as we've discussed before, that there are two separate rights involved, at least, maybe even more. But on one hand, you have the copyright in the photograph, which by default belongs to the photographer. And then separately, you have the right of publicity or right of privacy, which people have in their likeness, and which is, unlike copyright or trademark, which are federally established rights under federal law, rights of publicity and rights of privacy can vary a lot state to state. And there's no, registration for these rights. And there's a spectrum of how much protection depending on a lot of different factors. Celebrities or political figures have less protection than the rest of us. People have less protection when they're out in public than they do if they're in their own home. So, in general, if someone is a celebrity and they're out in public, paparazzi can take photos of them without violating their right of privacy because they're out in public and they're a public figure. So, the photographer owns the photograph and they're not really violating any right of privacy by taking it. The problem is the people who are in the photographs, the celebrities, think that because it's a photograph of them, they can kind of do what they want to do with it, which unfortunately is not the case under the copyright law. And I think a lot of these cases have been popping up because of social media. Because before social media, where is a celebrity going to post a paparazzi, or what are they going to do with a photo of themselves? Maybe hang it in their home, but it's not going to be distributed out to their millions of followers, which is what's happening now with social media. So I think that that's why you are seeing a lot of these cases popping up. And it also raises an interesting question, with music. It took a while, but finally we're at a point where, for the most part, a lot of social media sites have what they call blanket licenses to allow people to be able to use music in their posts without violating copyrights. So they've entered into agreements with record labels and music publishers so that people can create, TikTok videos or Facebook posts using music, and that there's a license to be able to do that. Again, it took years, maybe even decades at this point to get there, but a lot of it is now in place. And it'll be interesting to see if at some point they have some sort of similar arrangement for photographs, because, this comes up not just with celebrities reposting paparazzi photos of themselves, but people reposting memes or reposting any other type of photograph that belongs to someone else. There can be copyright liability there. So, it'll be interesting to see at some point if they implement some kind of a system to allow photographers to maybe get a royalty, and in exchange, they grant a blanket license for anybody to use the photograph on Instagram or Facebook or wherever it may be.
That's a good point. So, we have talked extensively about all these different topics that we just talked about in other recordings that we've done in discussing the music industry and copyright law and trademarks and all of that stuff. So if people want to learn more about that, they can certainly go back to our other discussions. But this is just, it's happening now. It's happening in real life, what we're talking about. And we just wanted to do this to show everybody that, we're not just pulling this out of a hat, it's real. So I think we'll probably continue to bring real world examples of what we are talking about and why it's important to copyright and trademark and all that, and get your business, your music business house in order. I don't know how you feel about that.
Yeah, I think that's a great idea. This way, we don't run out of things to talk about, and also people can understand, because it gets a little overwhelming. When people listen and they say, "Oh, I have to do all these registrations. Why does it really matter?" Well, these situations in the news show you why it matters, and you have to remember, yes, these people in the articles are now famous, but at some point they weren't. At some point they were just starting out. And so, to the extent this stuff is done early on, this way, when you get to that point, you don't have to worry about it. And these situations show you what could happen if you don't take care of it.
All right. So in the future, we will do more of this as it comes out in the news, these different topics, so that people can understand why it is so, so important to study and find ways to learn about the music industry and the business of making music. And Miss Cassandra, could you tell everybody how they can contact you and hire you for things like filing copyright registrations and trademarks and everything else you do, contracts? We did a big discussion about that. Could you tell everybody how they can get in touch with you?
Sure. Yeah. The easiest way is my website, which is cspanglermusiclaw.com. And from there, you can find, phone number, email, social media, everything you need. So again, it's cspanglermusiclaw.com.
Excellent. Thank you as always. It's always wonderful talking to you. We will do this hopefully more often and continue to come up with some topics. Oh, and if people have topics they would like us to cover, I think we're open to suggestions.
Definitely. Yeah, that would be great.
So, yeah, put it in the comments, folks. What do you want us to cover? Even if we already covered it, if you want more details or a different angle, throw it out there. We'll see what we can do.
Definitely. And thank you, Janae. It's always a pleasure to be on and to talk to you.
Pleasure's all mine. Thank you so much for doing everything that you do for us musicians. Well, that's it for this conversation, which means it's time for you to get out there and create, protect, and release.